Good morning, everyone. We're into the 5th day of the second session of phase 1. And I think we closed off early on Friday with a commitment from Mr. Streisfield about 15 minutes and or agreement on several issues. What's the update?
Sorry, we're just going to proceed for 3 to 5 minutes.
Okay.
Thank you, Mr. Manette. I just wanted to only ask you to provide your opinions with respect. Do you have any proposed opinions with respect to modifications to the Part 1 plan?
Yes.
And are they on screen?
Yes, they're shown I identified in blue as further modifications, NEC September 8th, 2020.
So these would be modifications to Exhibit 34?
Yes, that's correct.
And are they shown in blue?
Yes.
And can you please tell us what the basis of the modifications are shown in blue with respect to section 3.13 sub 5 and 3.1.4 open bracket 3?
Okay, these were added specifically as a result of Provincial Policy Statement 2020, and those are found in section 1.4 housing. And I'm just going to read the first, the relevant policy is 1.4.1, and that policy says to provide for an appropriate range of and mix of housing options and densities required to meet projected requirements of current and future residents of the regional market area planning authority shall, and then it lists a number of policies. But the terminology and housing options specifically comes from the updated provincial policy statements. So I felt it was appropriate to incorporate that into the secondary plan. And so that would address the first two.
And with respect to section 4416A?
I think that was just an addition by, there was an omission of the term FSI. We just added it to be consistent with the 2.5 FSI.
And then section 441 open bracket 7 close bracket?
Okay, that was a recommendation to delete the areas that are highlighted in blue, red, and crossed out. I think that was, some of those were the agreed upon deletions by the city, and I agreed and added some additional terminology. Effectively, it just makes the policy shorter.
And then with respect to 441 open bracket 9.
That was the correction of a typographic error.
And that's it?
And that was our, the only changes made that I'm recommending for that Exhibit 34.
Thank you, sir. Those are all my questions. Oh, sorry, we should have that marked as the next exhibit being Mr. Manette's proposed mods to Exhibit 34. Exhibit 59. Thank you, and I will send that around.
Mr. Chair, I believe the other landowners were going to go before me on these cross-examinations. I'm sorry, I think you're muted.
of. I'm not now. Well, is that the agreed order? Mr. Kussner first then, is that correct? Or you said the other landowners?
Well, I believe that all the other parties went before me for the other witnesses from NEC.
Well, yeah, but I'm thinking of your like interest with Mr. being in opposition. But
say somewhat.
I would say that both of our parties oppose the plan, but for very different reasons.
We gather that.
Okay, I'm prepared to go first.
Okay.
But I know last time it was Mr. Kagan that suggested that I shouldn't. The procedural order does say that I would go last in the order, before Mr. Iskander.
Okay. Well, whatever. Let's move. Somebody.
That's fine in your hands, Mr. Chair. I'm happy to proceed with my cross-examination.
Sure.
That's
Okay.
Tribunal's preference.
Okay.
Thank you. Mr. Chair, just for ease of reference, I 56A, which is the redacted witness statement. Exhibits 34 and 35, which are the Part 1 official plan modifications and the agreed secondary plan modifications with TSMJC, as well as Exhibit 57, which is 35, as well as some of the joint document books, Exhibit 1. And I'm going to be enlisting the support of my colleague, Ms.
You're muted, Mr. Kussner.
Unmute.
Can you hear me now? Great, thank you. Good morning, Mr. Manette.
Good morning.
Mr. Manette, in your evidence in chief, you talked a bit about your previous experience in the town of Richmond Hill, now the city.
Correct.
And one of the items you mentioned was your involvement on the appeals of the 2010 Part 1 official plan.
Yes.
And I just wanted to clarify, the client that you're currently acting for in this proceeding, NEC, it was not itself an appellant of the Part 1 official plan.
Not to
correct?
my knowledge, no.
And it was not a party to the Part 1 official plan appeals, even except to the extent of the policies that are at issue in this proceeding.
I just want to make sure I understand the question. You're talking about only Exhibit 34, the Part 1 plan?
That's the qualification that I'm putting to you, that other than to that limited extent, it's not a party, it wasn't a party to the Part 1 official plan appeals.
That's correct. It was not a party to the Part 1
Okay.
official plan appeal.
Okay, and I don't think we need to turn it up, but just for reference, the joint document book, Exhibit 1, Volume 10, Tab 47, which is the most recent partial approval order by the then OMB on the Part 1 official plan appeals. We've we've referred to this document previously, and there's a matrix that's attached to that order. The page reference is 3253. And I'm only referring to this because it lists the various appellants of the Part 1 official plan. And I just wanted to clarify for the record, your involvement in those appeals would have been on behalf of 3 appellants. One is appellant number 11, Hallover Investments.
Yes.
Another is appellant 25, Montanaro and Warden.
Correct.
And another is appellant 37, Robert Salna.
That's also correct.
Okay, so that would have been it.
As far as I recall, that's correct.
Okay, so basically, for all of the same appellants for whom Mr. Streisfield acted as counsel, you acted as planning consultant. Is that a fair statement?
On those 3, that's correct.
Okay, yes. And there's none others that you acted for?
Not that I acted for.
Okay. And you also made a point of previous work that you had done for Richmond Hill.
Yes.
And I just wanted to clarify, when would have been the last time you had been retained by Richmond Hill on a major policy matter?
I don't recall the dates, but it has not been recent. It was related to secondary plans at the northwest quadrant of Yonge and Elgin Mills, the southwest quadrant of Elgin Mills and Leslie, and the Yonge Weldrick area, which would have been the east side of Yonge Street, south of Major Mackenzie, which was part of the downtown plan. Those are 3 specific secondary plan related matters. Right. And I believe those began in the mid-late 90s and carried over into the first half of the 2010 era.
Okay.
So it was prior to the current OP 2010. Not on behalf of the city, no. No.
Mr. Chairman, it's Mr. Annabelle. I'm sorry to interrupt, but for those of us watching remotely, Mr. Kustner has frozen and we can't hear him.
We're trying to solve it with our... Okay. It's Monday morning, apparently.
Thank you.
Read shut.
Okay, is that any better? Can you hear me now?
I can hear you.
Can you see me now? Okay.
I can see you.
Okay, Mr. Minette, if I could ask you to turn up 56A, your redacted witness statement.
Yes.
And I wanted to start with paragraph 4. Just wanted to clarify for the record, you indicated here that you'd be giving evidence on the issues with a focus on the issues that I believe should form part of the phase 1 hearing. We can agree ultimately it's for the panel to decide which issues properly form part of the phase 1 hearing. Agreed?
I agree that has been decided.
Right.
And that has, I guess, been clarified through this particular document.
Understood. Okay, and you also refer here to the directions of Bill 108, More Homes, More Choice Act.
Yes.
And we can agree that since the adjournment of this hearing back in July, the province has enacted Bill 197, which contains certain amendments to the Planning Act relative to the Bill 108 version. Agreed?
Yes.
And one of those amendments, for example, is that under Bill 197, we're now back to the alternative rates for parkland dedication pre-Bill 108, right?
I will agree with that. I don't recall that I've reviewed that in the detail where I would be familiar with it to the extent I would give evidence on it.
Understood. In that case, I won't ask any questions on that. Okay. And you were here for the evidence provided on behalf of your client by Nixon Chan, the transportation expert?
Yes.
Okay. And you'll agree that your expertise is in land use planning, not on traffic, transportation, or parking matters. Agreed?
To the extent that I am not an expert in transportation planning and traffic and engineering, yes. However, my experience as a planner has involved working together with transportation planners and transportation engineers to coordinate their input into policy. So over my 45 years of experience, I have been involved in actually writing policies that relate to transportation sections of plans with input from experts. And in fact, in creating secondary plans in Richmond Hill, I was the author of the documents, but we had transportation consultants working together as part of a team. So my experience related to transportation planning is to work with the experts and then help through their input to create policies in a land use planning document.
Can you hear me now?
Yes.
We can agree that you've never been qualified as an expert in traffic or transportation matters yourself, right?
That is correct.
Okay, so we can agree that wherever you would express an opinion in one of those areas, you rely at least in part on the opinion evidence of Mr. Chan to support your opinion since you don't have that expertise yourself. Agreed?
That's a fair statement with respect to the technical aspects of the transportation planning and engineering. However, I may have opinions on the planning or the resulting planning policies that would result from his input that may not be exactly 100% with his suggestions with respect to transportation.
Okay.
Because I have to take that in as part of an overall input that may involve other aspects or other areas of specialty that lead to a policy that are not purely transportation based.
Okay. So in the interest of time, can we agree that wherever Mr. Chan gave evidence on cross-examination that either qualified or limited the opinion he gave on a traffic or transportation matter, your opinion would be so qualified or limited as well?
I'm not sure I can agree with that because I would have to hear the question to determine whether that was the case.
I see. Are you suggesting that there may be instances where your opinion differs from Mr. Chan on a transportation matter?
Not necessarily differs, but the end result with his input may be a different conclusion from a planning point of view.
Okay, I see. All right.
Because I may have to take in other aspects and build that into whatever the issue is.
Understood. Going back to your redacted witness statement, Exhibit 56A, paragraph 5. This is where you address the goal of the KDA secondary plan as you understand it.
Yes.
And in particular, you indicate that the goal should be to facilitate the creation of a complete community. And this is the part I want to focus on, in the most efficient way and without further delay. You see that?
Yes.
And that last part is repeated again at the end of the paragraph, without further delay.
Correct.
Firstly, my question is, where does that language come from? Is that a concept that you came up with, or is there some policy language where that without further delay test or goal is enunciated?
I think that goes back to my original reading of the staff report from 2017, where the commissioner, Mr. Kwan, identified the intent was to create a secondary plan that provided the opportunity to shorten the planning process by having clear policies so that an applicant can go straight to a site plan. And that would create the, I guess, without further delay part of it.
Right.
So that's my terminology interpreting what I read through the original intent of the plan.
Okay, so in enunciating that goal here, you indicated just now you're relying on comments made in the 2017 staff report?
And carried through the process, because I've been involved in the process throughout.
Okay.
And the intent, as I always understood it, was to have a secondary plan so that because there was a severe shortage of affordable housing in Richmond Hill, and because there was infrastructure that was being put in place with certain costs associated with that, it was important to get intensification on the ground and affordable housing built as soon as possible to deal with supporting public transit investment and also providing for affordable housing.
Okay, but in terms of that goal that you've enunciated in the most efficient way and without further delay, you're not suggesting that there is any kind of policy language that the tribunal must consider and apply in assessing the secondary plan. You're not suggesting that, are you?
Not with respect to words. What I'm suggesting is that in considering the secondary plan before the tribunal, that if that is an intention that should be kept in mind, then the resulting policies that come into play should try and work towards that intent.
Okay, but you'll agree with me that if the tribunal is satisfied that the version of the secondary plan proposed by the city would facilitate the creation of a complete community and meets all of the other policy tests, unless it's also satisfied that it's being facilitated in the most efficient way possible and without further delay, it should not approve the secondary plan. You're not suggesting that, are you?
No, what I'm suggesting is that in the consideration of the policies in front of the tribunal, that when reviewing those, the tribunal, and with respect, should keep in mind that policies that have the potential of creating any delay through their implementation may not be good policies. So in reviewing the policies that are before them, that's something to be kept in mind. The policies should be clear, easily interpreted, and lead towards efficient development as soon as possible.
Okay, and when you talk about delay here, are you referring to any kind of delay or only certain kinds of delay?
Well, an example would be where there are a number of policies that suggest there should be further studies before development can proceed or before development applications effectively can be considered, because my understanding of what should be in place for the secondary plan is the background study should have been done to lead to the policies that are before the tribunal. I don't believe it's appropriate to have a whole list of additional studies to be done and putting off decision-making into the future without having clarity as to what can occur in the short term.
Okay, let me give you another example. If a delay in the development process is attributable to a landowner who seeks greater development rights for its own lands than what the tribunal is prepared to approve for the rest of the KDA, you'll agree that that's not a kind of delay for which that's a kind of delay for which that landowner alone is accountable and not indicative of a deficiency in the secondary plan itself. Can we agree on that?
That's a difficult one to answer, given the matter in which my evidence has been curtailed, because I can't use any examples to provide a response.
I'm asking you as a general proposition.
As a general proposition, if there is clarity in the policies, then what you're suggesting is that there would have to be some amendment to those policies in order for that development to proceed. And the approval of the official plan itself would create a delay of at least 2 years before any amendments could be made to it. So I don't think that's a relevant issue. I think the key thing is to have clarity so that any landowner would be able to know exactly what they can and cannot do without having to do further studies to prove it.
Okay. And you'll agree with me that if the secondary plan as proposed is acceptable to a given landowner within the KDA, and it's prepared to proceed with development of its lands without requiring a single further OPA or zoning amendment, you'll agree with me that there can be no more efficient way to facilitate the creation of a complete community as it applies to that landowner's lands. Can we agree on that?
Well, certainly, and I think that that's the optimum conclusion, is if this plan was put in place so that any landowner could proceed on a development that would meet the overall policy intent and requirement.
Sure.
I don't have a problem with that.
Okay. And there's been a lot of discussion in your evidence about the concept of as of right zoning, right?
Yes.
In several places in your evidence, you emphasize the need to have quote unquote as of right zoning for lands in the KDA coming out of the secondary plan process, right?
Well, I was referring to the original staff report back in 2017 that specifically used that terminology, the as of right development. That doesn't necessarily mean as of right zoning, but the as of right development would be if you have a zoning bylaw being prepared,
Right.
if the regulations are appropriate given the current day situation, and they are effectively implementing the policies, and the policies are appropriate, then as a package, that should provide certainty, and certainty leads to an opportunity to develop as of right, because everybody would know what the requirements are without having to do further studies to prove things.
Okay.
That's the concern I have.
Sure. And you again referred us to the 2017 staff report as the basis for this concept of as of right development. But again, is there any specific policy you can point to at the provincial, regional, or even local level which specifically addresses the need to create as of right development?
No, I think that's just an understanding of how the process works. And if we are in a situation where we're trying to have a new approach to doing development through and policies, and especially with a new secondary plan, the opportunity with a new secondary plan is to take advantage of history and know what's going to work and what isn't going to work in order to have development able to proceed on a timely basis by having policies that provide for that, and effective zoning bylaw that implements those policies, so it can development application can move forward with limited amount of amendments to those documents. Yeah, for example, if you have a zoning bylaw in place implementing the new policies, there may be a need for minor variance to that. However, if there's a time frame before you can actually apply for those, then that would cause a delay. So if you have appropriate regulations that implement the policies for today's regime and today's intent at the higher level policies, that would provide for what I consider as of right development.
Okay. And as far as the lands within the secondary plan are concerned, firstly, we can agree that as far as the 70 Bernard retirement residence lands, there is already as of right zoning based on Mr. Conti's April 2020 decision approving the zoning bylaw as it applies to those lands. Agreed?
I would agree that there should be, if the document, if the approval is followed. But my understanding in reviewing the proposed secondary plan and zoning bylaw, that may not be the case. There may be impediments created by those documents that may cause a problem for as of right development.
You're referring to greenway matters that are being dealt with in phase 2. Agreed?
That's, yes.
Okay. And we've also heard evidence from the planners for the KDA landowners in the northwest quadrant and the southwest quadrant as to their support for the secondary plan and zoning bylaw as now proposed by the city. And in the case of Doliola and Yonge MCD, we've heard evidence about the concept plans they've prepared for their lands that are policy compliant with what the city is proposing in all respects. Agreed?
We've heard evidence to that effect.
And
yes.
you have no evidence to suggest otherwise?
To suggest that we haven't heard it?
No, to suggest that it's not policy compliant in some respect.
I would agree.
Okay. So we can agree, therefore, that if this tribunal sees fit to approve the secondary plan and zoning bylaw in the form now proposed by the city, it will create as of right zoning for the lands in the northwest and southwest quadrants, save and except the need to apply to lift the holding provision as it applies to those lands. Agreed?
I would agree if they followed the policies and the regulations as they were approved by the tribunal, correct?
Thank you. And we can also agree that in the phase 2 hearing, your client, NEC, will likewise have the opportunity to pursue as of right zoning for its lands, right?
Well, if there is an approved document in place with policies and regulations, so long as any application complied 100% with those documents, that would be the case, certainly.
So if it's successful in the further modifications it will be seeking for its lands in phase 2, it will have as of right zoning as well, correct?
That's correct, but it may not be based upon the policies that, in my opinion, would be appropriate for the KDA, given the intention of trying to achieve the level of intensification and the form of development that I think would be appropriate for this area.
That's your understanding of how it would work.
Well, that's where we see, and the recommendations that we made, and I guess will be considered in phase 2, would identify where we feel some of those shortcomings might be and why some of those policies and regulations should be adjusted. We've already given evidence to that effect, and that's with respect to the modifications that I've recommended.
Okay. And the same goes for TSMJC and Mr. DePette. In the phase 2 hearing, they will have the opportunity to pursue as of right zoning for their lands as well, correct?
I guess if that's the terminology, they would, all landowners in the phase 2 hearing would have an opportunity to recommend, through using their concept plans as the basis, what changes should be made to the policies and the regulations, and they would be based on an area or site specific basis.
Sure.
Although in the case of some of the information I put forward as recommended changes, my recommendation is that they should be KDA wide, because they're appropriate for the KDA as a whole, not just based on a site specific.
But whether it's approved KDA wide or whether it's approved site specific, that doesn't ultimately affect whether a specific landowner will have as of right zoning for its lands. Agreed?
Correct. And for the most part, a zoning bylaw, if one has an application that complies 100% with what the current zoning is, it would be as of right. So, and that's just a function of whether you meet all the requirements. Whether the development ends up being a good development or not is a secondary matter, but as far as the as of right development.
Understood. But we can agree that through this hearing process, all of the landowners within the KDA will ultimately have the opportunity to pursue as of right zoning for their lands. Agreed?
Yes, with certain exceptions though. If, for instance, the as of right regulations may allow a development to occur, that doesn't necessarily mean the development would be feasible to actually create.
Well, that's really for a landowner to decide whether it's feasible or not, right? Presumably it wouldn't be putting something forward if it wasn't feasible. Agreed?
That's correct, but
okay.
There may be impediments within the regulations or the policies that prevent a development from occurring because it creates certain impediments. Therefore, any development that would follow the policies may not be able to be done.
Right. And conversely, if a given landowner is unsuccessful in whole or in part in the phase 2 hearing, that doesn't mean that it will not have as of right zoning. It might have to apply at some future point after the moratorium for variances or a further amendment if it still wants to pursue greater development rights than what the tribunal has seen fit to approve, but it will still have as of right zoning for what the tribunal did in fact approve. Agreed?
Yes, with the caveat that I already mentioned. So there may be policies and zoning in place that on the surface would look, you could do certain densities, certain heights, certain parking, whatever that might be. But the end result might come to a development that is not feasible to do for other reasons. Maybe physical constraints don't allow that to occur on the basis of those policies and regulations.
Okay. And if we turn back to your redacted witness statement, Exhibit 56A, paragraph 6.
Yes.
You've here set out 5 broad areas or categories where you've raised concerns with policies in the proposed secondary plan.
Yes.
And the first one refers to height and density and land uses within the KDA. And just to clarify, as I understood your evidence, you do not have a specific concern with respect to the height regime that is now proposed in the secondary plan. Can we agree on that?
Correct. That is correct.
Okay. And as far as density is concerned, as I understand it, you do not have a specific concern with respect to the densities proposed on a KDA-wide basis. You have a concern with respect to density on the NEC lands. Can we agree on that?
Not 100%. the concern I had was the allocation of density within the northeast quadrant as a result of the decision on 70 Bernard, because that is a decision that is now in place, and the proposed density within the secondary plan does not recognize that.
Okay, and that's a phase 2 matter.
And that's, as we've determined, that would be a phase 2 matter. And in fact, it's not a major issue. It's just a slight readjustment based upon the approval decision of the board on the 70 Bernard site.
Okay. And as far as items B, C, and D are concerned, as I understood it, those are all still concerns that you have, even on a KDA-wide basis.
I want to read them to make sure. Yes, okay. And I think the modifications that we've outlined through the evidence I gave on Friday would outline what some of those are.
Okay. And with respect to E, the use of the proposed holding provision, as I understood your evidence, you are not taking issue in principle with the use of a holding provision. Your concern is specifically with the criteria that are being applied in the proposed holding bylaw regime. Agreed?
I think that's a fair statement, yeah.
Okay. Now, as far as these matters that you listed in paragraph 6 are concerned, you've heard the evidence from the expert planning witnesses that were called on behalf of the landowners in the southwest quadrant and the northwest quadrant, right?
Yes.
And you agree that they and their respective client landowners are now all satisfied that in all of these respects, the secondary plan is now proposed by the city constitutes good planning for their lands and for the KDA as a whole. You've heard that evidence?
Yes, I heard that evidence. I don't believe that they went into great detail on the policies respecting the KDA as a whole, other than to suggest that they were okay with those policies.
You'll agree with me that they are now all satisfied that they can meet the requirements of the secondary plan policies in all of the respects that you listed here in paragraph 6. Agreed?
Yeah, based on the evidence they gave, I would agree.
And you'll agree that they are all now presumably satisfied that there's sufficient certainty in the development process and that redevelopment of their lands can proceed to occur efficiently and on a timely basis. They're all satisfied in that respect, right?
Yes, and it's not unexpected they would be doing that because they're mainly greenfield redevelopment or greenfield developments. Okay. So they would just use those policies and create their development accordingly.
Okay. But yet in all of those respects, you, Mr. Manette, disagree with the conclusions that all of those other landowners, all of their planners, and all of their own transportation consultants have apparently now reached in all of these respects when it comes to their own lands. Is that the case?
I'm not sure I understand the last part. Certainly they would agree with it as it relates to their own land, yes. But I'm viewing the KDA plan as a whole.
Understood.
So there may be policies that are in place for the KDA as a whole that, in my view, certainly would allow the developments as they propose them on their lands. But if we're looking at the KDA as a whole, and this plan is for the whole area, it's not just for the west half, there are deficiencies in this plan, and there are concerns I have with this plan as relates to the whole area. Where there's greenfield development proposed, certainly they would be able to proceed on the basis that they don't really have impediments and they can implement those policies quite easily. And their concept plans certainly do that. So I have no problem with the west side as their evidence relates to their own lands.
Okay. So you have no problem with the west side, as you just said, as it relates to their own lands, but at the same time, you are still recommending KDA-wide modifications, including modifications to lands for which the landowners, their planners, and their transportation consultants have apparently now concluded that they are satisfied with the policies now proposed. Is that the case?
I wouldn't characterize it as that. My recommendations for the KDA-wide policy changes, in my view, would not have an adverse impact on those developments going forward as they've proposed them to be. They would be more in looking at the overall policies of the KDA plan to create a plan for the future that's good planning, that provides for the urbanization and intensification that is transit supportive for the entire area.
Okay. Paragraph 8, you refer to a negative planning outcome, and we've heard your evidence on this point. And the first item that you mentioned in this respect is the need for additional studies.
Correct.
And we've heard about the citywide stratification study and the citywide parking study that are currently underway, right?
That's correct.
Are there any other additional studies that you're referring to here?
I think some of the monitoring related aspects would result in some type of study where the onus is being placed upon an applicant to, in effect, provide for monitoring to prove something. And there's no real criteria that are set out as to how that can be accomplished. So that was one of the concerns I had. Okay. Those were the two main ones you mentioned that I have concerns
with.
But
the monitoring study that you just mentioned, that's not a study that needs to be completed before a development application can proceed in accordance with the approved secondary plan. That's a study that would take place following approval and a development application coming forward. Agreed?
Not as I understand it. I think in some cases, if I recall, the monitoring is the basis for having the developments approved, because the monitoring would determine whether or not the developments could proceed.
Okay. Can we agree, at least at the front end of the process, there is no monitoring that would have to be done before at least the initial development applications came forward under the approved secondary plan?
Well, certainly they could be submitted.
Okay. And as far as the citywide stratification study and parking study are concerned, can we agree that based on the anticipated timing of those studies, we can safely assume they will be completed before the NEC lands come before this tribunal at a phase 2 hearing?
I certainly wouldn't be able to confirm that. As far as the timing of the parking study, the parking study might be able to come forward, but the adoption of a parking strategy and parking regulations for an intensification area may not, because as you know, the 2010 parking strategy is still draft. And that was supposed to come forward many, many years ago. And in fact, parking has been applied to development applications more or less on a site-specific basis throughout the Yonge Street corridor during the time frame of the 2010 plan being in place. So the parking strategy really doesn't exist as of today. So there may be a parking study done, but there's a lot of studies that are done. They don't necessarily result in an actual implementation of a strategy or rates that would be appropriate for an intensification area.
But sitting here today, you don't have any reason to conclude that those studies will not be completed in time for the phase 2 hearing. You have no basis to conclude that. Agreed?
Well, we don't know when the phase 2 hearing is going to occur.
Right.
So that's hard to, I can't give you an answer on that one.
Right. Okay. And we can also agree that under the Bill 108 amendments to the Planning Act, there will be a need for the city to implement a community benefits bylaw regime. Agreed?
That's my understanding, yeah.
And you agree with me that that will require additional study, right?
That would be a reasonable assumption to make.
So presumably that's an additional study that you're okay with proceeding with the secondary plan for approval, even though that study still remains out there. Agreed?
I guess the implementation of an application approval that would require some form of benefit may precede the study based depending on timing. And once again, it may be a site-specific settlement arrangement.
Okay, but in paragraph 9 of your own witness statement, in the last sentence, you state, getting the details right now is also important since a new development cost regime is intended to replace the existing Section 37 bonusing regime, the details of which are unknown at this time. So you'll agree with me that you are nonetheless content to proceed with approval of a secondary plan for this KDA, even though there will be a need for further study to conclude the details of a new Section 37 CBB regime. Agreed?
I certainly agree that the approval of this secondary plan should be carried through to its conclusion based on its time frame, because as we proceed and as history has shown us, there could be a new piece of legislation next week, which creates new requirements, changes things. So we have to act in, and what we have in front of us today is what we have to deal with. So let's make it the best we can.
Okay. And you've also referred to, in paragraph 9, to the delays occasioned to date in the approval process respecting the secondary plan and relating zoning provisions, right?
Yes.
You'll agree with me that it was only in April, May of 2019 that the newly elected city council decided that it wanted to take this secondary plan in a different direction than what the previous council, which had adopted the plan, right?
That's correct.
Okay. And you'll agree with me, we know from the history that it sought and attained an adjournment of the hearing for that purpose, right?
That's correct.
And I agree that you and your client ultimately supported the adjournment for that purpose.
Yes.
Okay. And I take it you're not suggesting that there was any undue delay in the period between that adjournment and when the city ultimately brought forward its proposed modifications in May of this year. You're not suggesting that, are you?
Not at all. In
Okay.
fact, that was a relatively quick process based on past history for this type of process.
Okay. And again, in paragraph 9, you've also referred to employing all measures to reduce the cost of housing. You see that?
Yes.
And we can agree that the cost of housing is an acute problem, not only in Richmond Hill, but across the lower tier of York Region and many other municipalities across the GTA. Can we agree on that?
I would agree. Yes.
Okay. We can also agree that while reducing the cost of housing is an important goal that no one would seriously dispute, in relative terms, it's one of a number of policy imperatives that should guide and inform the development approval process in Richmond Hill and across the GTA. Can we agree on that?
That's a fair statement. And in fact, there's a mixture of matters that go into the cost of housing. And when we're looking at a KDA specifically, where we have intensification as a key element, and we have supportive transit as another key element, and affordable housing, those all tie together.
Sure.
So in fact, supporting transit and providing for housing that is not car oriented also leads to more affordable housing. And I don't use the term affordable housing as the term for assisted or supportive housing, but housing that is more affordable based on the market.
Okay, so we can agree that when we talk about the importance of reducing the cost of housing, it's of equal importance to ensure that development takes place on an orderly and phased basis to ensure that the necessary services and infrastructure are in place. We can agree on that?
I think that's a good planning principle, yes.
We can also agree it's important to ensure that when it comes to intensification, the need to deliver housing at a reasonable cost has to be appropriately balanced against the needs of existing communities and the impacts of intensification on those existing communities. We can agree on that?
I think as a general statement, yes, but where we have an intensification corridor adjacent to lower density, historically developed neighborhoods, the expectation based on my history in this business is that there will be conflicts created philosophically and perhaps even physically by having intensification immediately adjacent. So the transitioning is important. The character of how the development is put into place is important. But the ultimate goal is to achieve the higher densities and to support the infrastructure investments along the corridors where you have the infrastructure. So at the end of the day, there has to be a balancing act.
Sure.
And I think that's part of what the plan has to be able to do.
Of course.
And that's the role of planners and all the participants in the process. As I've stated before to this tribunal, everybody in this room is considered to be a city builder. So all of the inputs we have, including the residents who are here with their concerns and the policy planners from the agencies that are creating the plan and the development industry, at the end of the day, we all have to work together to create a plan that works and that it implements the higher level policies so that we can get affordable housing and supportive transit.
Okay. And we can also agree that the form which that housing takes can also be as important as the cost of the housing. So for example, in the context of the secondary plan, you'll agree that we want to ensure that the affordable housing is provided as part of a complete community with an appropriate range of mix of uses, at a high quality level when it comes to built form, urban design, and the public realm. Those are all important goals as well. Agreed?
And housing options.
And housing options. Okay. And I take it you're not suggesting that there's any specific policy at the provincial, regional, or local level which directs that reducing the cost of housing should be assigned a higher priority than some of these other important goals that you've also agreed with, correct?
I don't think there's a suggestion of a priority. I think there's a suggestion that there has to be consideration as that being an important part of the process.
Right. So we can agree that when you talk about taking, quote, all measures to reduce the cost of housing, unquote, that might be a bit of an overstatement. What you really mean to say is appropriate measures, but not at undue expense to those other important goals and objectives. Agreed?
Yes, and to not create impediments. And I think that's important. So where the opportunity exists to, as an example, and I've given this in my evidence in chief, by having standards for parking that provide the opportunity for zero parking households where people are going to be right next to transit and don't need cars is a consideration that should be taken into account and try and put into the process as far as the regulations that come out of at the end of the day. Okay. And there should be policies. The policies in general support that, but the implementation, in my view, hasn't been done to the extent it could be to accommodate that.
Understood. And if you then turn to paragraph 11, you say, about 4 lines down, ultimately the real focus should be on the wording of the proposed 2020 versions of the KDA policy and zoning regulations which remain problematic for development sites within the KDA on the east side of Yonge Street. You see that?
Yes.
So you'll agree that that was and remains the quote unquote real focus of your analysis. And ultimately, you don't have a great deal of concern about the secondary plan as now proposed for approval by the city and the owners on the west side of Yonge Street coming into force as it applies to their lands. Agreed?
I think there's a misunderstanding of my intent with respect to my recommendations for the changes to the overall policy in the KDA. The overall policies in the KDA should be more flexible to provide the opportunity for redevelopment. And in my view, that would not have a negative impact on the west side proceeding. But what it would do is allow for the overall KDA to move forward with better standards and regulations to meet the intent of providing affordable housing, providing support for transit, and not placing impediments on development. The implications may be more concerned with more of concern to the east side redevelopment than it would be for the west side. But in my view, the recommendations I've made in the modifications should not have a negative impact on the developments on the west side proceeding.
Okay. And if you could flip ahead to paragraph 13 on page 4, you talk about the various issues list and proposed modifications on behalf of other appellants and parties. And in paragraph B, you refer to TSMJC. You state that they have the same transportation concerns as your client, as set out there.
At the time I wrote the witness statement, that would have been the case as far as my understanding was at the time, yes.
Okay, but we can agree that as of today, TSMJC has now settled all of its phase 1 issues and that its remaining unresolved issues have been deferred to phase 2, where they will be resolved on a quadrant specific basis. Agreed?
That's my understanding, yes.
Okay, and similarly in 13C, you refer to the landowner to the south of Doliola, the Longos Plaza lands.
Yes.
And again, I take it since you drafted this witness statement, you've reviewed the minutes of settlement between the city and the owner of those lands, which were entered as Exhibit 9.
I believe I read them, yes.
Okay, and you've heard the evidence that those minutes of settlement do not contemplate or require any further modifications to the proposed secondary plan or zoning bylaw. They only provide clarification on how those policies are to be interpreted and applied in relation to those lands, right?
You want to say that one again?
You'll agree with me that the minutes of settlement that were entered as Exhibit 9 do not contemplate or require any further modifications to the secondary plan or zoning bylaw. Rather, they only provide clarification on how those policies are to be interpreted and applied in relation to those lands, right?
I don't think it's fair for me to answer that question without having that document in front of me to pursue in detail.
Okay, that's fine. You'll agree with me either way that those minutes fully resolve all of the issues that were raised by the owner of those lands, including the public road issues, and it no longer has any concerns with the policies now proposed in respect to public roads or any other issue. Can we agree on that?
No, I can't agree on that without once again having a look at the document. I understand that there is an agreement as a result of that, and whatever matters they may have would be at a later date.
Can we agree that as of today, your client is now the one and only landowner in the KDA who has issues with any secondary plan policies or zoning provisions in this phase 1 hearing?
The only landowner, as
Yes.
opposed to the only party.
The only landowner within the KDA.
Well, my understanding is that the parties on the west side have all settled, and TSMJC has a settlement in place. Any problems they have may be resulted in phase
Right.
2. And that may be, and if having heard the evidence from the other planners who have spoken to the tribunal, I believe I've taken a different view in my review of the document itself, because I've taken the more global view as to whether or not the overall secondary plan can be improved with changes to wording. I'm not sure the other planners really took that approach. It appeared to me, just from the evidence I heard, they were concentrating more on the impact on their individual landowner clients.
Sure.
So I've looked at it from two perspectives, as I indicated at the outset of my evidence, that I first of all reviewed the secondary plan as a whole, as a document for implementation, as whether or not that was good policy, whether it could be improved through modifications. And then the second part dealt with how that would impact on the Northeast Quadrant.
Right.
So it may be just
sorry.
because that NEC and the direction I had was to look at the overall plan. The approach I took was to look at the overall secondary plan area and make my comments on that. That may be why there's a difference, and why we may be the only landowner that still has issues.
Understood. But either way, whether it's because of the different approach that you're taking or for another reason, as of today, your client is the one and only landowner in the KDA who has issues with any secondary policies or zoning provisions in this phase 1 hearing. We can agree on that.
I would leave that to the tribunal to determine.
You can't answer that question.
Well, I'm the one who, or our position seems to be the one that has recommendations to change the policies in the plan.
Precisely.
So I guess if you want to characterize it as that, then I could say that's a fair comment.
Okay. If I could ask you to flip ahead to paragraph 16 on page 5 of Exhibit 56A. And here's where you've expressed an opinion in relation to the bus rapid transit line. And you've expressed the opinion that a break in the BRT system would be contrary to provincial policy. And I believe in your evidence in chief, you were asked, I think by the panel, how and contrary to what provincial policy? And as I understood your answer, it was that if you have major infrastructure like the BRT in place and no study that identifies a need to change that infrastructure, then it would be contrary to provincial policy to do so. Is that a fair summary of your evidence?
Right, and it's a general statement related to making efficient use of existing infrastructure.
Okay.
And in my view, if you start breaking into it, then you're not making the most efficient use of it, because you're requiring a change to something that's already been approved and put in place.
Okay, so that's the I take it that's the provincial policy you're referring to that it would be contrary to here, a policy that talks about making efficient use of existing infrastructure.
Correct, and the reason I said that is because the efficient use goes to whether or not there is any policy support for changing what has been put in place and has already been put into the infrastructure that's part of a major budget.
Okay.
So efficient use of that relates to the cost expenditures that have gone into creating.
Right. So, Mr. Manette, we've now been taken on several occasions now to the regional correspondence and policies where the region has said in effect that if in the future it's determined that a signalization is warranted in that location, then regional council could decide to install a signal in that location. And on that basis, it's the region's position that a potential future signal in that location should be protected for. We can agree in a nutshell that reflects the region's position.
That's the direction that they provided to the municipality.
Right.
So that's I guess that's the terminology they've used.
Sure. So can you help me? Just how is that in any way inconsistent with your position that a change to major infrastructure without a study identifying the need to do so is contrary to provincial policy? Isn't the requirement for a future study to determine whether a signal is warranted in that location, isn't that precisely the sort of study that you say is required before proceeding with a change to that piece of infrastructure?
That's correct to the extent where that would be the process, but as based upon all of the information and the background emails back and forth from the region and the transportation work that's been going on, I'm not sure that there's any basis for making the suggestion that there would be a need for that intersection for the next 20 years, perhaps, in which case, as I've indicated, there's no reason to put it in this secondary plan at all, because by the time you got to the point where you might need that, you'd probably be into a different plan regime, just based on the future timing and updating and changes to the document.
You'll agree with me, though, that sitting here today, nobody can predict whether 20 years from now there will be that need or there won't be. Nobody can predict that with any degree of certainty, right?
So there's no point in dealing with it at this point in time.
There's no point protecting for it at all.
Well, I'm not sure what the term protecting for it means. That's never been explained.
Never been explained.
So the uncertainty created by that statement is what causes you the problem.
I see. Okay. In your evidence in chief on Friday, you entered, there was an exhibit that was entered through your evidence. It was exhibit 58. And as I understood it, it was a proposed modification to Schedule 4 that you were recommending, which would indicate the location of the existing bus terminal in the southeast quadrant as an area subject to further study. Do you recall that?
Yes, based upon the concerns raised by the landowner and the recommendations that they had.
Right.
My concern was that as far as important infrastructure that currently exists in the secondary plan area,
right,
and that was something that I indicated should have been looked at through the opportunities and constraints analysis at the outset of the study to determine the importance of that bus terminal being in its current location. That if there was a need in the future, and once again, it's based on timing again, when I
right,
reviewed the documents and we heard the evidence on the potential need to expand the bus terminal, if that's something down the road that needs to be done, that should be, it's my view, it's important to maintain the location of that bus terminal as a fixture for the short term at least, because planning has to be done now around that being there. So if there's a need to study it further, it should be identified, and based upon the location of the proposed road network and or linear park that created almost an area around that bus terminal that would be appropriate for a more detailed study if there was a need to consider any changes to the bus terminal.
Okay, so we can agree that the existing Bernard bus terminal in its current location is also a major piece of transportation infrastructure like the BRT, which is currently under construction. We can agree on that?
I would agree. Those two specific transportation pieces of infrastructure are the important background infrastructure to the creation of the secondary plan and all the policies that flow from that.
Right. So can you help me, Mr. Bennett, why in your opinion is it okay to have a secondary plan schedule like your exhibit 58 that depicts the location as subject to a future study for a bus terminal, but not okay to have a schedule that depicts a location for potential future traffic signal based on a future study? Why is it okay in one instance, but not in the other?
Because the bus terminal exists today as part of the infrastructure.
As does the BRT, it's currently under construction.
Well, that's the reason why it's not appropriate to have a proposed intersection there. The intersection doesn't exist. The BRT exists, and with the BRT being there, it's a bit of a stretch to suggest you want to break it now But where you have an existing bus terminal, the potential exists where you might need to expand that. So that makes sense to have an area set aside for future study around the bus terminal because it's an existing infrastructure.
So in your opinion, that's a meaningful basis to distinguish between justifying having the existing bus terminal as an area subject for future study, but not the BRT that's currently under construction as being subject to a potential future traffic signal.
Right, there's a big difference because right now there's been an indication that at some point well into the future, there may be a need to expand the bus terminal. But the justification for the potential intersection is not based on any supporting study that's been done, in my view at least, that would lead to it.
Okay. I wanted to turn at this point to the demonstration plan that was filed by the city as a visual exhibit in this hearing. And the reference for that is Exhibit 1, Volume 14, Tab 81. Perhaps if Mr. Kahar can call that up on his screen share. Now, Mr. Minette, I think in your evidence in chief, you suggested that this exhibit was just provided by the city very, very recently as part of this hearing. You recall giving that evidence?
First of all, I'd like some direction from the tribunal as to whether it's appropriate to even have this in play at this point. If I was not able to use it or to reference the quadrant in my evidence before, I'm not sure where. Well, I guess I should wait for the question, but I'm not sure why it's being shown here.
Maybe you can wait for the question and we can deal with it if your counsel has an issue with it.
All right.
Firstly, you'll recall that in his evidence, Mr. Swinton confirmed that the same demonstration plan was made available to him back in early April. I would just ask you to confirm that it was also made available to you at that time as well. Agreed?
Yeah, on a without prejudice basis, right. We were shown this drawing. Okay. That's correct.
And that would have been prior to council's endorsement of the modified secondary plan in May of 2020. Agreed?
The timing, yes.
Yeah, okay. And in your evidence in chief, you suggested that this demonstration plan was really just intended to show how the height and angular plane regime in the modified secondary plan would work and how building heights could be accommodated under that regime. Did I get that right?
That's the way I interpreted the drawing based on what's shown on it.
Right. You'll agree with, firstly, you were here for the evidence of Mr. Theodore on behalf of the city?
Yeah, no, I wasn't here. I was monitoring.
You heard it.
Yeah, and okay. I think where I've been monitoring the process, and I don't recall, I was only here on Friday for the first time. Before that, I was monitoring it through YouTube.
Sorry, when I said here, I meant not physically present, but in spirit. You were here.
Thank you.
Okay.
Yes. I was involved in the hearing and watching it. Yes.
Okay. And you heard his evidence as to how this demonstration plan depicted not just heights and angular plane, but also how built form could be deployed in a manner which was policy compliant with the city's proposed secondary plan modifications. You recall that evidence?
Yes, but I believe we were able to, I guess, delve into that further because it was supposedly a site-specific or a quadrant-specific matter.
Okay. My question is just as a general matter, not on a quadrant-specific basis, do you have any basis to suggest that this demonstration plan doesn't demonstrate a deployment of built form in a manner that is policy compliant with the city's proposed modifications? You don't have any basis to suggest that that's not the case. Agreed?
No, based on the limited sketch that is before us, certainly the layout of those buildings, I guess we would have to test those with respect to how the setbacks are utilized because it's just a built form footprint. So the built form footprint, I guess, would comply subject to being able to analyze the setbacks, which are, it's not at a scale where you can actually do that. But in general terms, we're showing 4 towers and podiums and that type of thing.
So we can agree that this document consists of a demonstration plan which illustrates the deployment of built form, not just heights and angular planes, but built form which is policy compliant with the proposed secondary plan modifications. We can agree that that's what it depicts, right?
Right. And if we were able to talk about our concept plan, we would be able to show that it's almost exactly the same and would do the same, and in fact would fulfill the same requirements.
Well, that'll shorten the phase 2 hearing then, won't it?
We hope so, yes.
Okay. I wanted to turn now to your proposed modifications to the Exhibit 35 policies. And I believe that's now been entered as an exhibit. I think it was Exhibit 57.
Yeah. Now, I'm not sure if I have the exact version of that is marked as 57. I have what I wrote 57 on, but I'm not sure because I have so many different versions. So if you're going to refer to it, I assume you'll have it on the screen.
Raj, do you have that?
I have one. It looks 57. Similar. And is that the one that's updated July 9th, 2020? That's
how it's, yes, that's right.
And then we have NEC mods July 20th. I believe they are shown in blue. Is that correct?
That's the TSMJC mods. Yeah. While we're waiting to get that called up on the screen, I just wanted to clarify your proposed modifications to the stratification policy in this document, which starts at the bottom of the third page where you say renumber to 12.5.6 sub 2, and it carries over to the top of the next page.
Yes.
The first thing I wanted to clarify is your proposed modification to this policy. Does this contemplate stratification in the context of public streets, or does it only contemplate private roads with some form of public access?
I believe it would include the use of public streets as well, but it would be subject to if there was a need to have servicing under them, then that would have to be taken into consideration because, for instance, stratification allowed for underground parking, you would have to put the services in the underground parking area. So it would all be subject to that, but the intention is to deal with streets as a category as opposed to public versus private.
Okay, so you're not you're not recommending this policy to suggest that a public street should be preferred over a private street should be preferred as a policy matter over a public street. You're not suggesting that, are you?
I'm suggesting that private streets should be provided for and without having a lot of the requirements as identified in the current list that are here. So I don't think it's appropriate. We have to prove that the only way you can use a private street is that you can't use a public street.
And as I heard your evidence in chief, you went through the 4 criteria that were enumerated in this policy as proposed. And in at least 2 of the instances, C and D, you indicated that in your opinion, it was a reasonable policy subject to the comments that you provided, right?
Yes, can we pull it on the screen though, so we can refer to it?
Still trying to
do
that, I think. Okay. If you could, that'd be great.
Yeah.
Mr. Kushner, I wasn't sure which policy you were referring to in your last comment.
I'm sorry, Madam Chair. I'm still referring to the same policy. It starts at the bottom of the 3rd page where it says renumber to 12.5.62 and then over onto the next page.
You went past it, I think.
Sorry?
I think you just went past it. There it is. right?
Yeah.
That's the one we're referring to, right?
So you had indicated, at least in relation to B and C, that it was a reasonable policy subject to the comments that you provided.
Right.
Okay. But yet, in your proposed modification, you're proposing to simply delete these policies, these criteria C and D altogether.
That's correct, because at the level of the secondary plan, I think the intent of the policy is all that you have to put in, which is the first part. The expectation would be that if you're going to implement it, those other matters will be dealt with in normal course of review.
Right. And your concern in relation to C was that it's a reasonable policy, but there's no recognition of a site that has existing services already, right?
Right. Although, if for example, if you were to come in with an application for an underground parking area where the services are at the perimeter, certainly then it would be clear that it would not impede the city's ability to do those following matters, because they wouldn't be in effect, or they wouldn't. So obviously in a site-specific application, those matters will be dealt through the normal course of a site plan approval.
And as far as B is concerned, it can be demonstrated that the provision of a conventional public street would adversely affect the developability of a site. Your concern about that criteria was that it was a negative approach. It had a negative connotation, as you put it, and it's not appropriate to have to demonstrate why a public road cannot be used.
Well, that's not what it says. What it says is that you have to demonstrate why a public street would adversely affect the developability of a site. So therefore, without knowing what criteria you would have to meet, it could be determined that you don't meet the requirement without knowing what they are ahead of time. So it's sort of an open-ended concern I have. I think if the concept of stratification is appropriate, there's no need to have something like that. Stratification is something that should be incorporated into a development, and then based on how it will be implemented through a plan, that would go through a normal development process.
Okay. But you'll agree with me that having a policy that effectively contemplates no adverse impacts, that's a concept that we see commonly used in policy documents, both at the provincial level and at the local official plan level. Agreed?
Well, except where you have, it can be demonstrated that.
Yes.
Well, what is it that you have to do to demonstrate it? That's not clear at all. I mean, you're suggesting that it's appropriate that we have to demonstrate that it's not going to adversely affect the developability of a site, but I'm not sure on what basis that would be done.
You're confused by that? Doesn't give you enough clarity what's meant by the developability of a site?
Well, it's the onus is on an applicant to demonstrate effectively why you can't put a public road in and why a private road is acceptable.
Sure, but onus relates to the no adverse impact test, right?
Right, but it should be a principle of the plan that private roads are an acceptable form of development and stratification is appropriate.
In all circumstances? Is that your opinion?
As a general principle, and then when an application is filed, that would be dealt with through a site plan and through a normal review.
I see. So in your opinion, it's appropriate to have a blanket recognition or acknowledgement that a private street is appropriate without regard to the specific circumstances to determine whether or not it's appropriate?
Well, I think it's a given that through an application, the application would be recommending or coming in with a private road and stratification. And through the normal review and circulation, it would be determined whether that particular plan and that particular proposal was appropriate based on the normal review that takes place in circulation to agencies.
I see.
I think the principle in the secondary plan level should be that stratification is appropriate and that private roads are appropriate.
I see.
And then that would be the clarification on whether it's site specifically appropriate would be done based on an application. But the principle is what I think is appropriate to have in place in the secondary plan.
Okay. And as far as A is concerned, there is a council approved policy permitting the use of a stratified public street or private street for such purpose. So I understood that your concern with this was that it would require a council approval in the future. On this appeal, the tribunal is replacing council. It should make a decision that puts some finality or certainty to the policy and not leave it open to council. Was that a fair summary?
I think the matter is being dealt with in the policy. So effectively, if this tribunal determines that the use of stratified title is appropriate or stratification is appropriate for the secondary plan, that decision can be made now. Doesn't have to wait for a study, which would then go through another process, which could be extended through the normal council process that we've seen in the past.
So you indicated earlier, a few moments ago, that this policy, as you're proposing it, is intended to apply both to public streets and private streets, right?
The concept of stratification is a more general one, and the determination of whether in a circumstance a public or private street would be appropriate would be based on the application.
So I know you're not a lawyer, you're a planner, but is it your understanding that the tribunal has jurisdiction to require that dedicated public streets be subject to encumbrances? Is that your premise?
I don't think well, I wouldn't comment on it because I'm not a lawyer.
Right.
But as far as what this tribunal can do, it can approve the use of stratification as a principle in the plan.
So your understanding as a planner is that the tribunal can approve a policy that effectively requires a public street to be subject to encumbrances. That's your premise and understanding.
And once again, I'm not going to comment on the terminology that relates to a legal matter.
Okay, fair enough. In relation to the stratification policy that you're proposing, you also took us to a document that was provided at tab 28 of your exhibit 33, and it was the City of Guelph Parkland Dedication Policy. You recall that?
Yes.
And as I understood it, the purpose for which you referred to this document was because it was an adopted existing policy in another municipality that showed how stratification would work within the context of that municipality. You recall that?
Yes, it was an example that we were putting forward to suggest that there was no need to have an extended time frame for doing a study when studies have already been done, and staff in preparing the secondary plan could have or could use the information contained in other studies and see the conclusions and short circuit the need for a full study by just looking at what was done elsewhere and trying to apply appropriate principles that were applicable.
But as I understood it, this document applies to the concept of stratification in the context of parkland dedication. Is that a fair summary?
Yes, but the principles are identified in the study.
Sure. And you'll agree with me that in the context of Richmond Hill, it already has an existing policy in the Part 1 official plan that we're both intimately familiar with. It's section 3.1.8 that deals with parkland dedication, right? And I think it might be helpful to turn that up. It's in it's in Exhibit 1, the Joint Document Book, Volume 3, Tab 8. And it starts at page 577. And Mr. Bennett, you and I can agree that this is the Part 1 official plan parkland policy that was finally approved by the then OMB in 2015, right?
Right.
And I would ask you to turn to page 579. And if you refer to subsection I of the policy on that page, you'll see that it provides where council has determined that there is a need for parkland conveyance in whole or in part as a condition of development approval, council may give consideration to the acceptance of parkland for which there is stratified title. You see that?
Yes.
It goes on to say, without limiting the generality of the foregoing, council may consider accepting stratified title. It says parkland, perhaps that's a typo. If it can be demonstrated to the satisfaction of council that 1, the public has a reasonably similar level of access to that of parkland conveyed in fee simple, and 2, the limited title and associated physical conditions of the land to be conveyed do not unduly limit the intended role and function of the parkland. You see that?
Yeah.
So you and I can agree that this is an example of where this tribunal or its predecessor OMB has approved a stratification policy that effectively leaves it to council to decide whether it wants to consider accepting stratified title parkland in a particular instance. Agreed?
That's for parkland dedication.
Sure. Okay. And the criteria that it set out include criteria sub II, which talks about not unduly limiting the intended role and function of the parkland. In other words, they're criteria that are to be considered and applied on a case-by-case basis.
That's what this says about parkland dedication. Yeah.
Okay. So can you help me, Mr. Minette? Why is it okay to have a policy that leaves it to council to consider whether it wishes to accept stratified title in the context of parkland dedication, subject to specified criteria, but not okay to have a similar policy in the context of public road stratification?
Well, if that was the case, then we could put that into the secondary plan without having to do a study. But I think the establishment of the principle in the policy and having a policy that reflects that on its own is important to put into the secondary plan as a principle.
I see. So if in principle you had a policy that was worded in a manner similar to what we see in sub I of policy 3.1.8, in principle, you'd be okay with that?
Subject to having the ability to review it and confirm it, yes.
Thank you. I also wanted to refer briefly to your comments on sub-policy 8, which appears sort of mid-page, just after the one we were looking at in your Exhibit 57. And this is another policy, as I understand it, that you're proposing to delete altogether.
Okay, so we're out of this. We're out of the official plan now.
Yes.
Okay.
Yeah.
Good. And just want to. You want to pull that one up so I can see what you're referring to?
Sorry. It's this one here. It's just after the one we're looking at. Yeah. So this is a policy that you're proposing to delete altogether from Exhibit 35, as you've shown it here in Exhibit 57. Have I got that right?
Yes, and the reason we're deleting that is I've recommended deleting the section above that it would be applied to. So it wouldn't make sense to have that if you don't have subject to the requirements outlined in 12.4427 if they don't exist anymore.
Right.
So it was they go together.
Right. So in other words, you don't have to study it, just go ahead and do it. It shouldn't even be determined on a case-by-case or site-by-site basis whether it's appropriate. You should have a blanket permission without regard to the specific circumstances. Is that a fair summary of your opinion?
No. And as I've indicated, the normal site plan approval process would be in place. So the development itself would be subject to a full review, including the use of the stratification. My intention with this policy is to introduce the concept of stratification as being an appropriate land use consideration within the secondary plan at that level. And then through any specific application, the use of stratification on a site-specific basis would be evaluated through the review of the application itself.
I see. Okay. I wanted to then turn to your proposed modifications to 12.4.2.4, which is the policy mod that appears starting at the bottom of the first page of Exhibit 57. And you'll recall that in the May 2020 proposed policy, this section said development within the southeast quadrant, and Exhibit 35 proposed that that be changed to development within the KDA. And you're proposing to delete KDA and restore the wording southeast quadrant, right?
Yes. And as I've indicated earlier, I think we're recognizing that the bus terminal exists in its current location, and that should be a basis for moving forward with policies that relate to it.
Yeah. And in your evidence in chief, as I understood it, you suggested that Exhibit 35 would have the effect of modifying that policy in a manner contrary to anything City Council had ever studied or endorsed, by making it applicable to the entire KDA rather than limiting it to the southeast quadrant. Did I get that right?
Yes, that's my understanding. I haven't seen any studies that were in front of City Council that would have suggested that there would be a potential for moving the bus terminals anywhere within the KDA.
Okay. Can I ask you to turn up, and actually maybe Mr. Kahar can call it up, Exhibit 1, Volume 7, Tab 26. This is the original secondary plan as adopted by Council in 2017. And if we could turn to page 2272, 2272. And if we look at, this is section 12.4.2. And if we look at subsection 3 of that policy, you'll see that it says development shall support the potential redevelopment of the Bernard bus terminal. You see that?
Yes.
So we can agree that in this policy as originally adopted by Council, in accordance with the staff recommendation, it wasn't in fact limited to the southeast quadrant. It applied generally to development, which by definition would mean development within the KDA. Agreed?
Okay, I'm reading that. It says development to support the potential redevelopment of the Bernard bus terminal as an integrated use within the Bernard KDA. So it doesn't suggest that it would be moved from its current location.
I'm suggesting to you that the policy as originally adopted was not in fact limited to the southeast quadrant. It simply applied to development generally.
Well, I would say that's not a clear policy as to whether or not it's suggesting that the overall development in the KDA support redevelopment of the bus terminal in its current location. I would, because it doesn't say anywhere else, my understanding of that is if there was a need as a result of the development density or intensity that there had to be some redevelopment of the bus terminal, the expectation would be it would be in its current location. Now, that's the way I interpret that. There's nothing that would suggest that development would support moving it elsewhere, that it would just be redeveloped and redevelopment would be in its current location.
You'll agree with me that there's nothing in that policy as originally adopted that expressly limits its application to the southeast quadrant. Can we agree on that?
Yes, but in the same way, there's nothing that indicates that it would be changing its location, only that it would be redeveloped.
Okay. But what I'm suggesting to you is that by modifying the policy to read development within the KDA rather than limiting it to the southeast quadrant, it would in fact render it more consistent with the policy as originally recommended by staff and adopted by Council, not less consistent. Can we agree with that?
I don't think I can agree with that, because I think as it's written in number 3, it's not clear that it would be moving elsewhere. And I think what's being proposed here would be suggesting that it could float anywhere. So that doesn't provide for any kind of certainty.
Can we agree that there is nothing in the policy as proposed which contemplates changing the location of the existing bus terminal? Can we agree on that? The policy is speaking to a potential future development, redevelopment, right?
You want to pull that one up again so we can just make sure we're reading the document.
So you'll agree with me that the policy speaks to the potential redevelopment of the Bernard Bus Terminal. There is nothing in the policy that contemplates, directs in any way, anything in relation to the existing bus terminal, right?
Well, the concern I have is on the top of the page below. The ultimate size and location of the bus terminal shall be determined in consultation with the transit authority and all of the stakeholders. So there's a suggestion there that the location is not fixed and that there's a consideration of that it could be somewhere else.
Okay. So let me ask you this, Mr. Manette. Suppose your client, NEC, decides not to proceed with a redevelopment of its lands. And suppose that 5 or 10 years from now, it decides to sell its lands to another developer. And that developer decides that it wants to pursue a redevelopment of the Northeast Quadrant, which includes an expanded and relocated bus terminal as part of a mixed-use redevelopment of that site. Is it your professional opinion that it would be preferable to have language in the secondary plan which effectively precludes that potential future redevelopment from ever happening? Is that your opinion?
I don't think the language I'm proposing would preclude anything. In fact, if the region of York came along at some time in the future and approached the landowners in the Northeast Quadrant with whatever form of development they had, let's making your assumption that it hasn't changed from the current or maybe an expanded commercial based on what's there today. If the region came along and said, we think that we want to build a new bus terminal and we want to do it on your land and we want to do it together as part of an integrated development, they can do that anyway,
Sure,
without having a policy that would suggest that the current one is shouldn't be there.
Right. So we can agree that regardless of what the secondary plan expressly contemplates or not, it's always open to the region to enter into negotiations with a willing developer regarding a potential relocation of an expanded bus terminal at some point in the future. That's always something that could happen regardless of whether or not the secondary plan expressly contemplates it, right?
Yes, but that I expect would be based on some kind of study and analysis by the region that would lead them to that direction or conclusion. It would be based on a proper study and it would be based upon some reason to go somewhere different than the current one is.
And is there any, sorry, go ahead.
So as I said, the time frame that we're looking at here, based on the evidence I've heard and based on some of the internal memos, et cetera, contemplate that being well into the future. So not necessarily within the time frame of the secondary plan.
Okay. But we can agree that the policy as proposed by the city and TSMJC and supported by the region is a policy that contemplates the very thing that we've agreed could happen in any event, right?
Not in the way I've described it, because the onus should be on a study supporting a change, and that would be initiated by the region.
So you object to the policy in that respect because it doesn't expressly contemplate the need for a study?
Well, it's not based on any analysis that would suggest it should move from its current location in the time frame of the secondary plan.
Well, how could it if it's a potential future redevelopment?
But the time, what I'm concerned about is this particular secondary plan should have certain things that are established for certainty.
I see. Up to 2041.
Well, looking long term, 2041 is the horizon that the region uses. But as far as this particular secondary plan, its lifespan would likely be an official plan lifespan, which is usually 10 years.
Okay. 10 years. Okay. I wanted to turn to your evidence regarding the so-called ring road. Can we agree that from a policy standpoint, there is no such thing as a ring road in either the city's Part 1 official plan or the secondary plan, either the original adopted version or the modified one now proposed?
I certainly agree with that. And that was one of the concerns I had, because a lot of the staff reports and comments were based upon the concept of a ring road, which has not been established anywhere in the secondary plan itself.
Okay. So we can agree that whether it's a defined term or an undefined term, it doesn't appear anywhere in any official plan or secondary plan policy language or in any schedule. Agreed?
Yes, and that's one of the points I made in my comments on the plan, that it's not there.
So
there seems to have been, in Dan T's evidence, there seemed to be a lot of weight placed upon this concept of a ring road being an important backbone of the plan, in fact, for its transportation network and layout. But in fact, there's nothing in the plan that even refers to a ring road.
Right. So we can agree that when my friend, Mr. Strasfeld, asks you or other witnesses their opinions about ring roads, what they are, what their essential components or requirements consist of, and you answer those questions, both his questions and your answers don't relate to a term that actually appears anywhere in policy language or schedules. Can we agree on that?
Yes, and it's based upon evidence that's been put in front of the tribunal by the city witnesses and by others, and also in the staff report that was formed part of the record.
Okay. And that aside, I was interested to hear your evidence in chief as it relates to the notion of a ring road in this secondary plan. If I understood your evidence correctly, it was your opinion that as long as there are internal connections within each quadrant, there was no actual need for an additional connection from one side of Yonge Street to the other side of Yonge Street north of Bernard in order for a ring road system to function effectively. You recall giving that opinion?
Yes, and I think I was in effect quoting what I heard Ms. Sterling say, if I recall.
Right.
And I think that was, I'm not sure who asked the question, but I think her response was that you didn't need the cross connection because as long as you could serve the quadrants with connections to the main road system, which would be the arterial roads or collectors, then that was sufficient.
So you share the opinion that you can have an effective functioning ring road system without an additional connection from one side of Yonge Street to the other side of Yonge north of Bernard in that location.
Based upon the understanding that I heard the function of the ring road was supposed to be, which was to provide for the connection from the internal to the perimeter roads and some connection within the KDA. So for instance, if you're in the northwest quadrant and you want to connect to the northeast quadrant, you would use the intersection at Yonge and Bernard because that's not, first of all, distance-wise, it's close and you can still cross from one side to the other.
The last area I wanted to cover was your proposed modifications to the secondary plan, Exhibit 33, tab 19. And just before we get into specific modifications, in your evidence in chief, you prefaced your evidence on your proposed modifications by stating that there is a lot in the secondary plan as now proposed by the city that you do support, as an example, the height regime that's now proposed.
Right.
But your job as a planner was to try to make the secondary plan an even better document. You recall giving that evidence?
Yes.
And you're trying to improve the document, and in your opinion, it would be wrong to throw it out altogether. You recall giving that evidence?
Definitely. Okay. And I've never suggested that as an overall document, there's a lot of merit to the policies that are within it. And where I've seen the potential of improving the wording for clarity and for other reasons, I've made suggested modifications.
Okay. So let's suppose the tribunal ultimately accepts most of your recommendations on the mods that you say are needed to make the secondary plan even better. But in several instances, it says, thank you, Mr. Minette, but in these 2 or 3 instances, we think the secondary plan should be approved without your suggested improvements. I take it you'd still agree with me that the secondary plan should be approved even without those additional mods you are recommending to make it an even better document. Can we agree on that?
Let's say I would respect the decision of the tribunal. Sure. Because they are in fact the approval authority for the plan, and it would become the responsibility of them to determine what is appropriate and what is the best wording.
Precisely.
So my input is to the tribunal as a planner saying, based on my experience, I think this is an improvement, and they would then make their decision on whether they agree with me or not. That's their role.
Sure.
And my role is to the tribunal.
And let's just take that a step further. Let's suppose that this tribunal, after hearing all the evidence, says in effect, thank you very much, Mr. Minette, for your numerous suggestions. However, we don't think any of them are needed in order for us to approve the secondary plan in the form now proposed by the city. I take it even in that scenario, based on your own evidence, that you're really just trying to make it an even better policy document. You're not suggesting that the tribunal should not approve the secondary plan at all in priority to that approach. That's not your recommendation.
I don't think I've ever stated that.
Okay. So,
And if as you said, if the tribunal decided not to accept any of my submissions, I would be disappointed, but I would respect the decision. That's just the way the system works.
sure. And you'll agree with me that approving it even without any of your proposed modifications would be, to use your wording, less of a negative planning outcome than requiring the city to go back to the drawing board and start all over again. We can agree on that, right?
Yes, except based upon some of the recommendations I'm making, they would be for clarity, and I would think that the plan would be somewhat deficient in some of those aspects without making some changes, some of which I've recommended and some of which others may have recommended.
I see. And I take it from your evidence that you don't have a concern with this tribunal going ahead and approving the secondary plan with your recommended modifications, notwithstanding the fact that the region is still in the process of undertaking its regional official plan review. Agreed?
Well, based upon the regime we live in, there is always going to be some plan being changed over time. And in fact, Richmond Hill is undertaking its new official plan update. The region is undertaking that. The province is continually changing the provincial policy and the growth plan. So we have to deal with what's before us today, and that becomes the in-place documents until the next change.
Sure. And similarly, notwithstanding that the city has not yet undertaken its own comprehensive official plan review, you don't have a problem with the tribunal going ahead and approving this secondary plan with your proposed modifications.
Yes, and in fact, there may be some benefit to those types of approvals coming forward because they would then inform the overall official plan. And because of some of the new concepts or new changes accepted in a new secondary plan, they would have an impact on the future thinking that would go into the creation of the new updated official plan.
Right. And just to complete the thought, you don't have a problem with the tribunal approving the secondary plan, notwithstanding that the city has not yet brought forward its proposed secondary plans for either the Richmond Hill Center or the other KDA at Yonge and 16th. You haven't expressed any concerns in that regard either. Agreed?
No, and in fact, my comments would also apply to those, because if this plan was approved with certain new policy direction and suggested regulations in the zoning bylaw, that may impact the creation of those other secondary plans in the future as well.
So I take it, Mr. Minette, you don't share the concerns raised by the resident parties to the effect that it would be premature to approve this secondary plan prior to any of those higher order planning studies being completed, right?
That's correct. I don't agree with that.
As a planner, you agree with the other planners we've already heard from, and you're satisfied that this secondary plan can be brought forward for approval without those other studies having been completed.
When you say other studies, you're talking about the other updated plan?
Everything we just talked about.
Yeah, that's correct.
So can you help me out with this? Why is it that you acknowledge on the one hand, it's perfectly fine to proceed to implement this secondary plan without those higher order planning studies having been completed, but not okay to make the secondary plan subject to more specific planning studies, such as the citywide stratification study or citywide parking study? How is it that one is okay, but not the other?
I don't think there's an inconsistency there, because I think it's sufficient for the nature of the policy that I've recommended that it can be put in place in this secondary plan without having to study the whole concept of stratification, because stratification is a matter that's already in place in certain parts of Richmond Hill. So the concept is there already. It should be identified as an appropriate method for development in this secondary plan without having the need to study the concept and the issue itself. If the city stratification study is carried out and comes up with specific criteria that might be utilized in the future, that's different than agreeing to the concept as being appropriate.
I see. I just had a few questions about the actual policy modifications that you're recommending in your Exhibit 33, tab 19. And the first one I wanted to ask you about was your proposed modification to the vision section on the first page, section 12.1.2.
Right.
And as I understood it, you indicated that the policy, in your opinion, should be modified to indicate that instead of the Bernard KDA being envisioned to become the third most intensely developed area, that should be changed to read the second most intensely developed area, right?
Based on the timing, yes.
Right. So based solely on the timing, there will be at least an interim period where once this secondary plan is approved, if it's approved by the tribunal, it would effectively, in my term, leapfrog over the 16th KDA because it hasn't been approved yet or adopted yet for that matter.
Well, in fact, its density would be higher than the density in the most recent version of that.
Right.
Although I don't believe that has status at this point. The other option, of course, is to not worry about second or third and just indicate that it would be one of the most intensely developed areas in Richmond Hill. And that matter would be determined through the new urban structure in the new official plan as it comes forward.
Right.
So, but I don't think by putting it third, then the second place one doesn't exist, then there's a problem. It would be like, it would maybe a tie for second. I mean, it's the same thing if you have, the terminology there just would be inaccurate to say it would be the third if there wasn't a second.
My point, Mr. Minette, and you can agree with me, there's nothing in the Part 1 official plan policy that contemplates that the Bernard KDA would be the second most intensely developed area in Richmond Hill. That's not part of the Part 1 official plan, agreed?
That's correct.
So even by recommending a policy that contemplates just that, even on an interim basis, wouldn't that be recommending a modification that isn't supported by the Part 1 official plan?
Suffice it to say that I'm not too concerned that that's a major impact change.
Okay.
I was just recognizing the hierarchy as it would exist at the date of this was to be approved in advance of the Yonge and 16th Avenue secondary plan. I don't think the world would end as we know it if that was not there.
Thank you. I also wanted to ask you a question about your evidence with respect to the secondary plan taking precedence over the Part 1 official plan.
Okay.
First of all, you'll agree with me that if we look at the Part 1 official plan, and it might be helpful to actually turn that up. It's in volume 3 of Exhibit 1, tab 8. And the policy reference is 7.1.12.
Okay, what's the actual page in the document itself?
That's what I'm trying to clarify. Just give me 1 second.
Seven 7.1.8, is that the one you're referring to?
7.1.12.
Oh, 0.12, sorry.
It's on the screen. It's at page 671. So we can agree that there is already existing policy in the Part 1 official plan, which provides that in the case of a conflict between the Part 1 plan and any secondary plan, the policies of this secondary plan shall prevail except where this plan expressly provides otherwise. That's already in the Part 1 OP, right?
Correct.
So to the extent you had a parallel policy in the Part 2 plan, in this secondary plan, it would in effect be repeating a policy that already prevails in the Part 1 official plan.
Yes, but I think it's appropriate to have it in the secondary plan as well. So
Understood.
You don't have to go back to find it in the primary plan.
Understood. Okay.
As long as there's no conflict between the two, it's better to state it again so it's a standalone document.
Understood. You know what, I'm going to leave it at that, Mr. Minette. Those are all my questions. Thank you very much.
Well, we have arrived at the 11:30 break for morning, and we'll come back at 1:45.
Thank you.
Okay.